just in case you didn't know, it's the first time we've run this particular session. I've been kind of resisting it for 4 or 5 years because it's such a contentious subject. So we hope you find it useful. And as ever, if you have any comments or feedback, please feel free to let us know. As you probably all know, disputes about deliberate deprivation tend to be particularly contentious, I guess because of their nature. And of course, they very often relate to quite large sums of money. So the consequences of this issue arising for the individual concerned and their family can be quite significant. So I'm hoping we will have time at the end for questions, but I do need to say at the outset that we can't give you judgments on individual cases. Ultimately, that's a decision for your local authority, GCC, and it's their view that counts. But what I hope the session will do is give you lots of guidance, lots of examples on how different situations are likely to be viewed should you find yourself in disagreement with the local authority. So hopefully you will get answers even if they're not entirely specific. I think it's important to start off by remembering that the gifting of our money or of our assets is not illegal. It's our choice, and we can basically do as we wish. But there are a number of instances where we have to take into consideration the law. I guess the first and most obvious one is inheritance tax. If you make gifts, then the HMRC have the right to consider adding them back into your estate on your death when calculating your inheritance tax. Another one is if you're acting as power of attorney. Our power of attorney legislation prohibits us from making gifts in the capacity of an attorney without approval from the court. I do get some people who think that because the court has approved a gift, that means it, by definition, cannot then be deprivation, but that's not true. You can get approval from the court to make gifts because it's in the best interest of the individual and still fall foul of the deprivation rules. You will be treated just the same as anybody else. And of course, the fourth example is when you've made gifts in order to affect your claim for funding support in a care situation, which is obviously the one we're going to focus on today. It is probably fair to say that there is also an issue of deprivation, deliberate deprivation, in terms of benefits as opposed to care funding. The rules are slightly different, the legislation is slightly different, and some of the case law is different. I'm not going to address that today. I'm going to focus on deprivation in terms of care funding, because that's obviously the issue that affects most people most of the time. So I guess we have to start, just to be clear, with the legal definition. What is deliberate deprivation? It is, according to the law, where a person has intentionally deprived themselves of or decreased their overall assets in order to reduce the amount they are charged towards their care costs. That's the official definition of what constitutes deprivation. For those of you who need to know, the legal reference point for this is the Care and Support Statutory Guidance, Annex E, paragraph 6. A riveting read if you've got nothing to do, but that will basically set the premise of what deliberate deprivation is. It's also worth bearing in mind that most laws in this country are evolved and developed through case law, through actual precedent and issues that take place. You should bear in mind that there is almost no case law on deliberate deprivation for care funding. And the main reason for that is the cost of making an appeal, which we'll come to a little bit later on. So whereas you might look to say, oh, let's see if we can find an example in the past where this situation has arisen and how it should be dealt with, you'll find almost nothing there, which makes it quite difficult. So we have to rely on the framework that we have, and I guess a good place to start is is what is the legal position, if you like, on deliberate deprivation. And the situation is quite clear. There are three elements that need to be considered. And it's important to bear in mind that all three elements must be present in your situation for deliberate deprivation to be deemed to have occurred. So not just one or two, all three have to be there. So I'm going to read you the three because this really is the essence of the argument. So number one, was avoiding or reducing the care and support charge a significant, underlined, motivation in the disposal of the asset? Number two, at the point the capital was disposed of, could the person have had a reasonable, underlined, expectation of the need for care and support? And number three, did the person have a reasonable, underlined again, expectation of needing to contribute to the cost of their care? So those are the three criteria. I will come back to them. So if you've not quite sort of registered them all, don't worry. But all three have to be present in order for deliberate deprivation to be claimed. Now, as you probably noticed, the three underlined words, reasonable, twice, and significant, are hugely subjective. Who decides what that avoiding care fees was a significant motivation or that a person had a reasonable expectation? So because you've got such a subjective reference point in all three of those criteria, that's why you've got so many disputes about it. Now, just because a gift has been made, deliberate deprivation should not automatically be assumed by the local authority. The problem is that in reality, if it looks like deprivation and smells like deprivation, you can be fairly certain that the local authority will claim it is. Because they'll be looking for you to explain some of the reason or some of the motivation, if you like, for why that took place. So if they look at your situation and they reject an application for care funding because they believe that deprivation has taken place, your local authority must explain their reasons in writing. It's not good enough for them just to say no. They have to explain clearly why they believe that to be the case, and they would have to effectively reference those three circumstances and claim that they are present. Now, the thing that does cause a bit of confusion is that the burden of proof is actually on you, the individual, the person who made the gift, to be precise. Burden of proof is on them to show that deprivation has not occurred. So it's not the responsibility of the local authority to prove it has, which is a very important onus of responsibility. But having said that, you only need to prove so on the balance of probability, not absolutely. In other words, that it was more likely than not that deprivation didn't occur. So if you just pause at that point, we've got three hugely subjective words in the criteria. We've got the local authority probably wanting to claim deprivation has taken place as a default position. We've got the onus of responsibility on you or the person who made the transfer to prove it didn't take place, but they've got to do so on the balance of probabilities. It's hardly surprising on the basis of that this causes so much trouble, because that is open to endless consideration and interpretation. And what I want to do today is take you through some examples of what falls on which side of those rules and why, because I'm hoping then that you'll be able to work out how the situation might apply to you, if it's something that you're worried about, something that's happening, or something that might happen. So I'm going to start by looking at this issue of motivation. As we said, was the ability to reduce your contribution to care a significant motivation? Now, the local authority only has to show that the avoidance of paying for care was a significant factor, not the only one. think some people feel it's got to be proven as being the only reason why you did this. That's not the case. There may be a perfectly reasonable reason for a gift being made, but that doesn't mean that significant motivation wasn't there alongside that. Let me give you an example that might illustrate the point. Giving money away to a child who's been made redundant. They're facing losing their home because they can't pay for their mortgage. That would be, in anybody's mind, a perfectly legitimate and valid reason to make a gift. But that doesn't mean that the individual who did so wasn't significantly motivated to deprive themselves of capital if at the time they did that, they were 86 and had just had a stroke, for example. So you have to look at the reasonings alongside everything else that's taking place at the time, the age of the person, their circumstances, what might have been taking place. I have a particularly good example that kind of illustrates this, and it was a case I dealt with a couple of years ago. And it was the motivation, if you like, in this particular example was fairness. It was a chap who had 3 children, and he decided to downsize, buy a smaller property, and he deemed to give each of his 3 children £10,000 to help them buy a house. The first 2 gifts, the first 2 children, took their gifts immediately because they were keen to buy a property or upgrade their property. But the 3rd child didn't want the money because their job provided them with accommodation. I think they worked in the licensed trade. So the 3rd and final gift took place 8 years later because the daughter then changed job, lost the accommodation, and went to Dad and said, "Can I now have my £10,000? The thing is that by then, 8 years later, Dad had developed a care need. So at the time of the 3rd and final gift, 2 of the 3 elements that I referred to earlier that are required for deliberate deprivation were satisfied. Dad knew that he needed care because he was in a care home. He also knew that he would have to contribute because he was doing. But there was still the question, the 3rd element was avoiding care fees a significant motivation? Now, in this case, the local authority just took one look at that and said, deliberate deprivation, we're not going to pay. And the matter was challenged, and the argument was put forward to explain that this final gift was, if you like, a commitment, a liability, if you would, because the gentleman concerned had documented his actions and effectively had made a promise to his 3 children. And when he made that promise 8 years earlier, he had no expectation of needing care and no awareness that the gifts he was making would entitle him to state funding. So the local authority overturned their decision when challenged and said, yes, okay, we accept the point. So I think that's a pretty good example of illustrating how difficult it is to arrive at definitive answers unless you look at the whole situation that's taken place and all the circumstances that might prevail at the time. So what kinds of actions, situations would most likely be deemed deliberate deprivation? As I said earlier, the law is quite clear. People should be treated with dignity and respect and should be able to spend the money that they've saved as they wish. The law recognises that it is, after all, their money. But deliberate deprivation can still occur, particularly if there is no obvious other valid reason for the gift. So the most obvious one is a transfer of property or a transfer of money to somebody else. That should also include transfers into trusts, which I suspect we will come back to as we work our way through things today. One of the most common examples I come across of people getting confused is that they will say, but I've just used the gift allowance of £3,000 a year, or the £250 a year allowance for gifts to grandchildren. So therefore, it must be okay. We have to explain to people that these are not rights or entitlements. These are actually inheritance tax exemptions. So if you don't have an inheritance tax liability, you really have got no chance of claiming that you've had to use these allowances because you're avoiding something that doesn't exist. And therefore, the local authority would probably say that that isn't a valid gift. Next, please. And if you haven't got the next one, then you're very much into the issue of deprivation. Yes, I suppose houses, property are the most common example of serious deliberate deprivation arguments. And the usual explanation I see is that the individual will say, I just wanted to make sure that my children inherited the house. Sounds like a perfectly plausible and reasonable explanation. But you should expect the local authority to turn around and say, well, that would have been achieved by writing that down in your will. You didn't need to give it to them today in order to ensure that, unless you were trying to deprive yourself of assets that would qualify under the means test for care. So I'm hoping you're beginning to see how these different things kind of shape up and the direction of travel it takes us into. Those are the obvious ones, property and houses, but there are quite a few others that are a bit more subtle, a bit less obvious. I'd just like to touch on those, if I may. Probably the most common one, the one that causes maybe the greatest argument, is if you help somebody to buy a property, but you don't put your name on the title deeds. Let me explain. Simple example of that would be mum decides to combine the sale proceeds of her house with the sale proceeds of her son and daughter-in-law so that they can buy a larger house with accommodation for mum so that she can be looked after. Quite a common situation. But when the transaction takes place, mum does not put her name on the house deeds. So legally, she's not an owner. 5 years later, care is needed. And the local authority step in and say, well, that contribution that she made from her property sale is an outright gift. It was clearly done at a time when a care need was anticipated, because otherwise, why would she want to move in with family to look after her? And therefore, deprivation would be deemed to have occurred unless you can explain why you did it. And I think you would struggle. Now, strangely, this is one of the odd ones, because it would be far better in a situation like that for mum to put her name on the deeds and for that position to be represented by the proportion of capital she's invested in the house. Let's just say it was 30%, just for simplicity. So it would be better if the house deed said owned by mum, 30%, and by son and daughter-in-law, 70%. Because that clearly is not a gift. She's merely decided to buy a different house that's more suited to her needs at the time. Now, let's imagine care is needed 5 years later. What would the situation be? Well, the local authority would be required to assess the value of her property. And this is where it gets interesting, because people assume that you value a property by taking the value multiplied by your share of it. So let's imagine the house was £300,000. The lady owns 30% of it, therefore her assets are £90,000. That is absolutely not true. You have to do it the other way around. Instead of value times proportion, you say, what's the proportion and what's it worth? In other words, what is a 30% share in a house worth? Well, the first question would be, which 30%? Is it the front garden, the back garden, the upper bedrooms? So the truth is that the local authority then have to value that asset. What is, imagine putting on Rightmove for sale, 30% of house, in which son and daughter-in-law, 2 kids and the dog will continue to live because they're not selling. So what you've got then is a situation where there will be a dispute about the value. The upper figure would be 90,000, taking the simple 30%, 300,000. but the bottom figure would be zero. You could argue that sharing that house is worthless because nobody would want to buy it. Who wants to live in a house with two other people that they don't know? So that's a good example where trying to do it, I'm not say sneakily, trying to do it without putting your name on the deeds, thinking that'll be fine, actually gets you in more trouble because that just walks straight into the hands of the local authority being able to disregard the entire transaction as a gift. Whereas if you represent the position as it was, you've at least got the grounds to have an argument of what is that 30% share worth. Now, just before we get too excited about this, I've had cases in London where the property is worth 1.5 million, and you wouldn't get away with the local authority suggesting it was only worth 30%. But as we move further north, that gets a little bit more sensible because the property values obviously are generally lower. But what you'll find now is in order to try and find out what's taken place, most local authorities, not understandable, not unreasonably, I should say, are more inquisitive. So when I first started doing this, the question used to say, do you own a house? No. Move on to question 2 that was about something else. Now, the questions are likely to say, do you own a house? No. If no, did you ever own a house? And if yes, where is it? Or where are the sale proceeds? So the local authorities are becoming more inquisitive to find out what's gone on in the past so that they can then have a look and ultimately try and challenge that situation. Another example that's a little bit more off the normal would be investing in disregarded assets. The best example I can think of this is it's a weird one. It's life assurance investment bonds. That may mean absolutely nothing to you, or you may have come across them. These are insurance-based policies operated by the likes of the Prudential and Standard Life. And it's a peculiarity of our care system that they are deemed to be exempt from needs testing. It's a bit of an accident, really. The legislation was meant to deal with policies for your funeral, when we all had a man come round from the Prudential on a Friday night and collect 10 bob offers for our policy. That was what this thing intended to mean. But there are particular investments where the life assurance is 1% of the value, but they still qualify to be exempt. And these were quite popular, particularly 20 years ago. You meet lots of people who had them. But if you deliberately choose to invest in one, when you could reasonably have expected a care need and to have to pay for it, then the local authority can claim deprivation. And I have one particular example of this because it really was terrifying. This was a lady who had held exactly such a bond since she retired 25 years ago. She then went into care. The bond was disregarded and the local authority paid her fees. No argument, no question, because it was clear that 25 years ago, she wasn't thinking about care and having to pay for it. Her financial advisor, who was not particularly skilled in the world of care, came to the family and said, we're going to sell that bond and we're going to put it in another one because it's going to perform better and it's going to give you better returns. And they said, oh yeah, fair enough, that's okay. And the local authority got to find out about it and said, no, that's deprivation. Their view was that she'd sold bond number 1 and put the money in the bank and then decided to buy bond number 2. When she bought bond number 2, she was in care. She knew all the things that could happen. She even knew that these things were disregarded. And therefore, they claimed deliberate deprivation and refused to fund care. And the cost to the lady was £200,000 for one piece of incorrect advice. So my advice to you is make sure you get the right advice at the right time. Don't just do something because somebody who doesn't quite know what they're doing suggests that might be a good idea. So a salutary lesson of how you can just by accident find yourself in a position of deprivation. Another slightly sillier example is the goods and chattels are exempt from the means test. So technically speaking, if you went out and bought an original Lowry and hung it on the wall, that value would be disregarded from your means test. But if you bought it at a time when you could be expected to need care and your intention was to deprive yourself, then quite obviously that would be exempt. Other examples, again, slightly more unusual. If you split something, the best example I can think of, not that any of us have got them, but if you had a pair of Ming vases and you sold one off because it's only worth a quarter of the price that they would be worth as a pair, then that would be deemed as deprivation. And that could be applied to lots of things. So again, you've just got to be careful. These are the things that a local authority might be looking at to see if you have devalued your assets. Coming back into something that's maybe a bit more mainstream, and a very common issue today, I have to say, is the disclaiming of inheritances. You may or may not know, but there is a legal mechanism whereby after a person's death, the beneficiaries, or one beneficiary, or all beneficiaries, if you like, can decide to redirect the inheritance to a different person, or more commonly to a trust. In other words, I don't want it, give it to my son, give it to a trust. That is known as a deed of variation, if you ever come across it, but that is generally only used for inheritance tax planning. So if you have an inheritance taxable estate and you inherit another £100,000 from your uncle, you might reasonably say, I don't want it. I want to pass it to the next generation because otherwise I'll have a bigger tax bill. But if you don't have a tax bill, then you would struggle to argue that your reason for doing that isn't deliberate deprivation. And we are seeing lots more of those taking place. This didn't used to be the case 5 or 10 years ago, but we are seeing more and more people reaching a care age and still having a mortgage. If you pay off your mortgage early, that is deprivation because you're paying the loan back earlier than required. If you had a loan that was repayable on demand, fine. But if you had a mortgage with 5 years to run and you found yourself going into care, so you think, right, I'll quickly pay off my mortgage and get rid of this cash that I've got, then you would expect the local authority to treat that as deliberate deprivation because you voluntarily paid your debt off early. Hard one to prove, but substantial expenditure which is out of character. So if for 10 years you've been spending £100 a week on your personal items and you suddenly start spending 500, expect the local authority to ask you to explain why. And I'm going to end this little session on what might constitute deprivation with again, a particularly common issue, which is funeral plans. It seems to me now that almost everybody, the moment they suspect a care need may be on the horizon, are encouraged to rush out and buy a funeral plan. And my advice would be timing is everything. If the person needs or is likely to need care when they purchase a prepaid funeral plan, it is highly likely that will be viewed as deprivation. Why? Because the local authority system allows you to keep 14,250 of your savings. You won't be expected to make a contribution, and their view is that's more than enough to pay for your funeral. So why do you suddenly feel the need to pay for it in advance at a time when a care need is anticipated? So that is likely to be viewed as deprivation. So are we all thoroughly depressed now? Because you're probably all thinking, well, there's no escape, is there? This is just... But it gets worse. Before it gets better, it gets worse because we've only spoken so far about deprivation of capital. You have to consider that there is also deprivation of income. Best example I can think of there is if you are not taking, or you stop taking income from an asset. Two simple examples. Those investment bonds I mentioned earlier that are exempt. One of the main reasons why people invested in them years ago is that you can take 5% a year out of them in a fairly tax efficient way. I won't go into the details as to why, but I see lots of people who, when a care need appears on the horizon, they stop taking that 5% income that they used to take. And the local authority will pop along and say, why? You're depriving yourself of income that you've had for the last 20 years and you've suddenly stopped now. So we're going to presume that you are receiving your 5% income from this bond. Very easily done. Again, you've got to make sure you get the right advice. Maybe, again, one that's not been as common, but is becoming more common. It's more and more likely now to meet people who are of a age who haven't taken their pension benefits, particularly their private pensions. So imagine you had a £100,000 pension pot that you decided not to take any income from, and then you find yourself in care at the age of 75. The local authority will look at that and say, well, you're not taking an income by choice, but you could take an income. You could go out and buy an annuity that would pay you £10,000 a year. So we're going to assume that you are doing just that. It's your choice whether you want to, but we're going to assume that you will have notional income of £10,000 from your pension. We will adjust our contribution accordingly. And it's just worth bearing in mind that with a private pension, there is a rule that allows you to have 50% of it disregarded if you are physically paying that to your spouse or civil partner. So again, you might actually be better to take the income and give half of it to your partner or spouse, assuming, of course, you have one, and then you would be assessed on the balance that you keep, rather than let the local authority assess you at the full value because you haven't yet taken the income. And I just have to make one sort of final technical point on income. I don't know if it'll be relevant, and if what I say now means nothing to you, then that's fine. But the income rules I've just described and the payments received do not apply if the source of the money is a discretionary trust, providing that the individual concerned is not a trustee. So the example I would see of that is husband and wife. Husband leaves his estate to trust. His wife is a beneficiary and a trustee, and then she needs care 5 years later. The family would say, don't pay any money to mum because it will only contribute to a care need. And in that situation, the local authority would be able to claim deprivation. So if you have an elderly parent who is a trustee of a family discretionary trust, make sure you get them off the register before they need care. That probably won't apply to most people, but it is definitely a growing example. Okay, so we've spent the bulk of our session so far speaking about what is deprivation. I've got to try and rebalance with a few examples of what isn't. But I have to warn you that they're rather fewer than the ones that are. So let's look at a couple of simple things. Even in these examples I'm going to give you, if you look at the broader picture, it would still be possible to argue that deprivation has taken place. For example, you make a gift of £500 to somebody as a thank you for the care and help that they've provided while you were recovering from a hip operation. I don't believe that that would constitute deprivation because you're not going to deprive yourself of too much capital at £500. It's not going to make a great deal of difference to your overall position. Spending more money each week than the personal expense allowance for people in care, it's £30 a week. That's supposed to be the amount you're allowed to keep to pay for your toiletries, newspapers. Well, you can't buy a bottle of gin for £30, can you? So I don't see why you should stop doing things like that just because you're in care. So my advice to anybody who is spending more than the £30 PEA is to just keep the receipts. When anybody comes and asks, you can say, look, that's what I've done with it. Because your local authority may be suspicious that it isn't real spending. Because obviously, if you said to your children, please go and buy my toiletries, and they buy all their own as well, then that would be a bit obvious. So if the local authority look at your receipts and you bought 27 toilet rolls, then maybe they might think you're also buying them for another household. So just take care. My favourite example of not deprivation is joint bank accounts. If elderly or older people have joint bank accounts, that's usually a bad idea, because if one of them needs care or has a care need, however minor, it might just be a bit of help at home. What you want to make sure is that the payment of that help is coming out only of the person who has the needs savings. If they're coming out of a joint account, then effectively the person who doesn't need care is subsidising. So when I see people who have £50,000 in a joint bank account and they pay everything out of that, it's much better to have two 25s and make sure that all of the care related bills go out of the person, out of their 25,000 and not the other person's, if that makes sense. I want to kind of come around then to again, an increasingly challenging area. This is the issue of married couples who own a property together. One person moves into care and is funded by their local authority because their interest in the house is disregarded. It's disregarded because their spouse occupies it. So they could have a £500,000 house in Cheltenham, and providing they've got less than 23,250, the local authority would fund that cost with no charge relating to the house. But of course, then you've got the situation where the person at home is now rambling around in their £500,000 house in Cheltenham and decides this isn't really suitable. It's too big. It's not quite as close to the family as it would have been, as would be handy. And they decide to sell and move somewhere else. Now, if they sell their £500,000 house in Cheltenham and buy one in Chipping Norton, and the person in care maintains their ownership, then nothing changes. The exemption will continue. If you do this, I would strongly recommend that you correspond with your local authority first. Tell them what you're going to do, tell them why you're doing it, and effectively get their agreement, because the reason the exemption applies on the property is because it's the person in care. It was their main residence. But in the example I've just given, it was never their main residence. They never lived in Chipping Norton. So you've got to make sure that the council are aware of this, and generally speaking, they will not have an issue. But of course, that's not normally what people do. What most people in that situation I've just described is they downsize, they buy a smaller house. So they go from a £500,000 house in Cheltenham to a £300,000 house, creating £200,000 worth of equity. You have to remember that equity is split equally between the owners. So suddenly the person who was in care and was having their care fully funded by the local authority will instantly be deemed self-funding with £100,000. I personally think that is wholly wrong, because you've effectively got a system that is preventing the person at home from living a sensible life, moving to a more manageable property, a more affordable property, not least because their husband's pension is now being used to fund his care. So that to me is wholly and totally wrong, but I have to explain that's how the rules are. And exactly the same thing applies for equity release, because that would be the obvious way around it. Well, let's release some equity on the property. I'll stay where I am, even though I maybe don't want to. Unfortunately, our system only allows equity release to both owners. You can't equity release on the person who's at home and not the person in care. And I personally, I've lobbied for some years about that to see why you can't equity release on part. The reason you can't is because the banks and insurance companies don't want to have an argument in case they have to evict you. Simple as that. It's not anything to do with what's in your best interest. So again, got to be careful if that's part of your thinking or planning, that equity release could, it's not deprivation as such, but it kind of creates the same outcome, which is why I've mentioned it. So having hopefully give you some indication of what is and isn't deprivation, let me very briefly conclude by explaining what happens if it is. So just to recap, the council must explain in writing why they have taken the view that they have. You then have the right to go back to them and challenge that, but you will need to give more information to try and change their mind. And I'd refer you back to the example I gave of the chap who was giving the £10,000 to each of his children. At the time the council made the original decision, they weren't aware of the background. And when that was presented to them, they changed their mind. If that proves unsuccessful, you do have the right to request an appeal. It's a very legalistic process, effectively like a court, and you're represented by a lawyer and so are the council. And all they will do, just so that you know, is they will go back through the records to try and find something upon which to base their claim on. For example, a medical diagnosis 5 years ago that just happened to be before the gift was made, a claim for attendance allowance, any number of things that they would be able to access in your records that could say, isn't it coincidental that this occurred just before the gift was made? And that puts you absolutely on the back foot, and you really are struggling to defend yourself. You would get little or no change out of £5,000 for that process. Most people don't do it. And that's why there's no case law on deliberate deprivation for care funding. Because most people sit and think about it and think, I'll probably lose. When you apply all the things we've tried to cover today. You do have the right to refer the matter with no cost to the local government social care ombudsman, entirely free. And I get lots of people who are marching off there with their papers in their hand, ready to do battle. And then I have to say, stop, this is not an appeal process. The ombudsman cannot overturn a decision. They're just there to make sure that the process and procedure was correctly followed. They can't overturn a decision, even if it is wrong or unfair. All they can do is say, you didn't follow the procedure, Mr. Local Authority, please go back and do so. The most common example of that is you didn't put your reasons in writing. So you go through all the process of going to the local government ombudsman, and the outcome is, dear Mr. Local Authority, please write to the client and explain why you treated their actions as deprivation, and that would be the end of the case. So it is unbelievably difficult to overturn a deliberate deprivation conclusion unless you have exceptionally strong evidence to support your claim. The best advice I can give is don't get yourself in that position in the first place by using all the things we spoke about today to make sure you've got your ducks in a row and that what you've done is explained, that you're just aware of what that might look like. Now, this is the only bit that swings back in our favour, I guess. For most people, the gifts that have been made have either been spent, invested in a house. So the idea that the local authority can say, right, we're going to treat Mr. Jones as though he's got £200,000 that he hasn't got, and therefore he's got to pay for his care. Well, if he hasn't got the asset and he hasn't got the money, what happens next? And the local authority have a duty of care to provide for that care need and pay for it. They can't avoid that. That is their legal obligation. But they will seek to recover that money from the person who received the gift. And that might be by way of a lump sum, or they may say, we'll accept £200 a week from you, or whatever arrangement they may come to. But you have to bear in mind, they have the full power of the Insolvency Act and the County Court at their disposal. It is an option of last resort, but it is nevertheless the option. So, as I say, my advice to everybody is if any of the things we spoke about are issues in your family, think about it long and hard. Just consider how the what, when, why would be viewed if you were the director of social services at the local authority. Just try and flip it the other way around. And I've just scribbled down a couple of sort of final thoughts, really. The one that didn't obviously have an obvious place to put in the discussion we've had so far is this issue of timescale. Lots of people say to me, but I did this more than 7 years ago. It's okay. Unfortunately, it's not. The 7-year rule that most people know about and refer to is the gifting period for inheritance tax. It is an inheritance tax issue. It has nothing to do with care. There is no timescale for care, because if you go back to the 3 examples or the 3 issues I described, you may have developed a knowledge and an awareness that you needed care at 53, but you might not go into care till you're 75. But that doesn't change the fact that if you disposed of any assets at that time, that deprivation wasn't in your mind because you meet the criteria. So there is no time scale. Agreed, the longer ago it took place, the better, because there's less chance that at 43 or 53, you were aware of what you might need at 85. The closer the time scale is, the closer the gift is to the claim for care funding, the more reduced your chances will be, unless you have clear evidence as to what that might be. Now, as a sort of final note of cheer, if that's the right word, not every local authority has the same approach, the same resources, I have to say the same quality of staff. So what you'll find is that some are far more aggressive and inquisitive than others. Some are completely overwhelmed by workload with not enough staff, and they don't notice that deprivation has occurred because they haven't got the means to check. And that's just a statement of fact. That's just the way it is up and down the country. And an authority that might have been a bit behind the door, so to speak, might suddenly become really hot because they brought in some extra staff, because they realise that they're missing issues of deprivation. And equally, authorities that were very keen, suddenly they lose a couple of people. And so it's an ever-moving feast is what I'm really trying to say. But the one thing I would say is we have to remember that the individuals in the local authority are not making a personal attack on you. They're simply following a process that they are required to follow by law. And we do have to understand that as the financial pressures on every local authority increase, literally month by month, they have no option but to pursue these issues to try and make their books balance. So it's not a condemnation of something you've done, and it's not personal, but it is nevertheless extremely annoying, very painful, and as we've said in many of the examples we've touched on today, if it goes wrong, it can be extremely expensive. So, as I say, not the easiest of subjects to cover, and you can probably understand now why we haven't done this session before. But I hope that we've at least been able to explain some of the whys and the wherefores. I have no idea which of these may affect you. Maybe none of them do, but the key thing is to try and make sure that people have at least an understanding of the consequences of action that they may have undertaken or be considering or have in their family dynamic. And you've got the chance then to go back and revisit and have a look at it. So, as I say, I hope that's been useful.